Well, welcome everyone. We have quite a range of people from all over the country. It's really cool. And I think this is going to be a very interesting topic. I know there's a lot to know about human resources, and I'm really glad that Lynda and Pam can be here today to share their expertise. Just to give you a little background, Dr. Lynda Ring-Erickson has over 20 years of experience as an administrator, consultant, and educator. She has worked in both the public and private sector to help organizations with strategic planning, training, investigations, and team building. Pam Ward has more than 25 years of experience in all aspects of human resources. She has worked in both public and private sectors as a manager and provided HR services ranging from labor relations and problem solving to policy development and implementation. I want you to welcome them today, and I'll turn it over now to Lynda and Pam. Thank you.
I'm going to interject. We do have a couple of things to cover before we pass it over. Our lovely facilitator who you just heard is Diane Hutchins. Thank you, Diane, for stepping in for Carolyn today. For technical support, you have myself, Jeremy Stroud, and I will type this information into chat so that you have it throughout the session. If you're having any difficulties at all, please feel free to call me or send me an email. Email is going to be the easiest because I'm actively participating in the session as well. But do not hesitate, especially if it's a pressing concern. Give me a call. More than happy to step out and assist. And this session is brought to you by the Office of the Secretary of State, and of course we're with Washington State Library here. And we're partially funded by the Institute of Museum and Library Services, the LSTA funds that allow us to do what we do here. Now, last but not least, before we pass the mic over, we are required to track participants. We don't need a lot of information. We'd just like to know your name, your organization. If you're out of Washington, if you can just tell us what city and state you're in as well, that would be very, very handy. And we just pass this on, and it shows how useful this session is. I mean, we never envisioned this as being a national audience originally, and it is growing so large. It's fantastic. So if you can just type that out for us, we'll give you a couple minutes, then we'll go ahead and get started.
Okay, Jeremy, are you ready for us?
I think so. I still see a few individuals typing. I'm going to go ahead and start recording these here. And if you haven't typed it, please do so. Otherwise, I'm going to be typing it out during the session that, hey, I still need that information from you. I hate to be so onerous about it, but we're required to track. So, all right, Pam, Lynda, thank you again for joining us. And Diane already read that wonderful introduction, so now I will pass off the microphone. Everyone, please welcome Lynda and Pam.
Thank you very much. Thank you for the nice introductions. We are a full-service human resources and organizational consulting service. Under normal circumstances, we would even be able to honor your requests for music because Pam has a lovely singing voice. Unfortunately, Pam is not doing so well and has been not able to speak very well the last couple of days. And these topics today are generally her area of expertise. So she's going to try and start us off, and if all of a sudden you hear a voice change, it's because she's pointed at me and her voice can go on no longer. We do encourage people to ask questions as we go along. We have plenty of time and would love to hear actually what your concerns are and what you're working with, because that's how we improve our services. LRE Solutions is a consulting company. We can offer everything from full-service human resources to just consulting on a particular project, like a performance audit or a employee handbook. So with that, we'll start to move ahead and talk a little bit about human resources red flags and what you need to know. The materials today are primarily developed from the questions we get from customers about what it is that they're perceiving a need for help or an emergency. That's usually when you call in extra human resources help. So that's why we called it red flags. Today's discussion is going to center on those particular issues, and we have 3 subjects we're going to talk about today, but we're open to any questions at all you might have. And with that, I'm going to turn it over to Pam.
Okay. As Lynda said, my voice is a little challenged this morning, so hopefully we can get this out. Today we're going to talk about, first of all, the Fair Labor Standards Act. We're going to talk a bit about communicating with your employees and the hiring and termination processes. So, without further ado, the first one we're going to talk about is the Fair Labor Standards Act. This is a very big law. I'm sure you have all heard of it. The things that we're going to talk about from within the Fair Labor Standards Act are these 3 items: the minimum wage, the overtime provisions, and exempt versus non-exempt employee classifications. Those are the topics that we do get most of our questions from our clients on, and that we help them with the most. So, first of all, Lynda's going to tell a little story about something that she experienced as it has to do with the Fair Labor Standards Act. So, Lynda?
Okay, most of you, I gather from kind of looking over the list, and by the way, I'm really impressed by how many of you are from places further away. At one point, I worked for the state of Washington, and I was brought in to my sort of job as a manager and administrator was to bring programs back into compliance. I came into a major program that had over 320 employees and was in a state of disarray. An individual had been working there for a number of years, and he had told his employer, his supervisor at several staff meetings, that he had too much work. He just couldn't get it done during the day. And her response had been, well, you're just going to have to figure out a way. I think that had they been understaffed, it might have been a little bit of a different outcome. But in any case, Ben, we'll call him Ben, caught up with his work, and the supervisor noted that he was getting caught up but never asked how he was doing it. Over the course of about 18 months, Ben continued to be caught up, and nobody asked him how he did that. At the end of the 18 months, he and his attorney showed up one day and asked for 4,080 hours of compensation time at time and a half pay. This went to court, actually. It was unfortunate for all concerned. Ben prevailed in court, got his 4,000 plus hours at time and a half, a new job assignment, and the state ended up paying the court costs. This was a real big eye-opener for, I think, this is a large state hospital. But it was also a real eye-opener for me as somebody who came in and then tried to put the program back together after that kind of experience. So with that, we'll let Pam talk a little bit more about the Fair Labor Standards Act and why we think it's important.
Okay. The federal minimum wage is currently $7.25 an hour. Now, in Washington State, the minimum wage is $9.47 an hour, which currently is the highest minimum wage in the United States. However, wherever you do business, either within the state of Washington or your other states, you must comply with the most generous provision of each law as it applies to the employees. So if your state minimum wage is higher than the federal minimum wage, that is what you must pay. If you have a local jurisdiction that has a higher minimum wage, for example, the city of Seattle currently has a minimum wage of $11 per hour, and it's on its way to $15 an hour, which has been a rather large controversy in our state. But whatever the higher rate is what you must pay. There are a couple of exceptions to paying the full minimum wage. For example, if you employ children between 14 and 15, you may pay them at 85% of the whatever minimum wage you're paying. And in Washington, that would currently be $8.05 per hour. And if you happen to be in a business, which I doubt that anybody on this particular session is, in a place where tips are included, in our state, tips are not part of the minimum wage. In some states, perhaps Georgia, I believe I saw that somebody from Georgia is here, it can be included as part of the minimum wage. Okay, our second topic. Missing a slide here. Oh, here we go. Are the overtime provisions. Now, in our state and in the federal statute, any hours worked over 40 in 7 consecutive days must be paid at time and a half the regular rate of pay. You must define your work week. It is 7 consecutive days beginning on the same day each week for all workers. You cannot have one work week within your jurisdiction for one employee and a different work week for others. It has to be the same. If you allow your employees to take work home, as occurred in the example that Lynda gave us earlier, they must keep track of their hours and you must pay them for that time during the same pay period that it is worked. It is not a good practice to allow extra work at home. You have no control over how many hours are involved, and it's just not a good practice. Overtime is not based on pay periods, and in our state, it is not based on an 8-hour workday. I believe I saw a person on the list who's also from California. In California, it is based on an 8-hour day. You must pay time and a half for any hours worked over 8 in a workday in California. And there may be other states that have that same regulation. Be sure that you check to see whether your state is on an 8-hour time period or a 40-hour week. The only limitations on the number of hours allowed for workers are for teenagers under the age of 18. And for example, one of those is during the school year, when they're going to school, they can only work so many hours in a week, and I have it right off the top of my head, and it may vary from state to state. Comp time is something that a lot of companies like to consider giving to their employees instead of paying them time and a half. Under the federal statute, only public employees and only under certain conditions are allowed to do comp time. And it also, if you do provide comp time, must be at time and a half. So that is, did anybody have any questions on those 3 items by chance? Okay. We will move on to the employee classifications. This area is, first of all, the most complicated and also the most violated section of the Fair Labor Standards Act. The primary...
Pam?
The primary...
I apologize. We did
yes.
have a question come in at the
yes,
very
Jeremy.
end there, asking you to define public employee.
Well, let me see. Anybody who works for a public agency. In our state, It would be state employees, county employees, city employees. I believe that your library system in the state would be considered public employees also. That is something you might want to check for sure on, but I'm pretty sure that that's the case. Any other like public utilities in Washington State are public employees. That's what I can think of in right off the top of my head. Did you have another thing, Lynda?
Yeah, I was just going to add, there is some case law that where the state, in Washington State anyway, has extended retirement benefits to some of the associations. And under those circumstances, if you've been included in the state retirement system, you are considered a public employee. Here we have, and I think almost all of you have like a state cities association, state counties association. Frequently, they've been extended the state benefits in the retirement systems. So you might want to use that as a guideline, because certainly case law in several of the West Coast states has extended public employee status to those individuals as well.
That answer your question? Okay. Okay, moving on to employee classifications.
And excuse me, Lynda or Pam, we have another question. Someone's wondering if it's recommended to have a comp time policy in your personnel manual.
Absolutely.
Yes, that answers the question we have here. Thank you.
Okay, thank you. The three most commonly, excuse me. Sorry about that. The three most commonly used employee classifications are the executive, the administrative, and the professional classifications. And they are, the executive one is pretty easy to define. The administrative one is the hardest to define. The professional is pretty easy to define also. There are others that are also exempt from overtime, for example, outside salespeople. But the key to classifying your employees is not by title. The key is in the duties and the salary levels that you pay these people. Because the duties are so important, it is really important also that you have written job descriptions for all of the positions in your organization. Because if you want to be sure that you are exempting someone from overtime legally, you must have the correct duties in their job classifications. And it's very complicated, particularly with the administrative ones. There are a lot of gray areas. And it's a good idea to write them down and talk to an HR professional, or if you happen to have a legal attorney that you work with, to talk to them also. You just simply cannot give an employee a manager or supervisor title and consider that person an exempt employee. The actual duties of the job are what is important. The Labor Department has set new records for aggressive wage and hour enforcement recently, and now has strong new standards in place to better protect workers' pay. The ultimate burden of supporting the actual application of the exemption tests rests on the employer. Most of your employees will be non-exempt and will be subject to all provisions of the Fair Labor Standards Act. Okay, do you have any specific questions on these items? Okay. If there's anybody with us who has a union contract, sometimes you are you find yourself in a different kind of a position, but we'll get more into that a little bit later.
We do have some individuals typing right now, so there are some questions. Is there a minimum salary for an exempt employee?
Yes. Yes, there is. A minimum salary currently is $23,660 a year, or $4.55 per week. However, what I was just going to say is there is a rule change that has been proposed that will affect all of these white-collar classifications, and that is to raise that standard from $23,660 to $50,440. If that change becomes effective, it certainly will drastically affect many employees that are currently classified as managers or professionals. They will either lose their exempt status and have to be paid overtime, or employers will need to raise their salary levels above the new minimum level. It will drastically also affect compensation budgets. It hasn't been approved yet, but it's looking like it might be. There is also an additional thing that kind of affects the people that are currently classified as exempt, and that is that if they are reclassified as non-exempt, they often equate such a change to reducing their status in the organization, which is a difficult thing to have to deal with. So just keep that in mind. It isn't in effect right now, but it's looking like it might be approved. Okay. Those are the 3 items that we wanted to discuss about within the Fair Labor Standards Act. At the end, if you have any other questions about the Fair Labor Standards Act you might want to ask us, why don't you give us those, and maybe if we have time to answer them, we'll try to do that. If not, perhaps you can write them down and we can get back to you on them. Okay. Our next topic that we're going to discuss is about the communication with your employees. Now, Lynda also has another story for us.
This makes it sound, the way we're doing this, like I've had all these horrible experiences as a supervisor and administrator, and I really haven't. I love the work. And this actually was not mine directly, but it had to do with an operation where a city that I worked for had a contract with an employer. The employer had put an ad in the paper asking for an employee with specific training requirements, and an individual applied and got the job. He signed an application stating that he had those current certifications and that he understood what was expected of him to keep those current. He was given a handbook which clearly said that the training was the employee's responsibility, and he signed that as having read it and understood. Now, in the course of this contract, of course, he was hurt doing a city job, and in Washington State, government does not have sovereign immunity, meaning that when we go to court, the government is the deep pocket, even if the direct employer went bankrupt. So it was about a $5 million lawsuit. So the city had an involvement in this. It was on a construction job, which probably the certification is probably not particularly relevant to today's discussion, but the individual had clearly said he had it and that he understood it was his responsibility to keep it current. He understood that when he applied for the job, that was one of the requirements. In this particular case, the government and the employer prevailed because it had been made clear and that the employee had signed in several places indicating that he understood that responsibility and it was his requirement. And the injury, although it wasn't disabling, was serious enough that it required a lot of medical. But the government and the employer did not end up paying that because the individual had several times testified and certified that he had the training. So with that in mind, that's just an example of one done well, and I'll turn it back to Pam.
We do have a question in between there. Rosalie Old says, we do comp time at King County Library and don't pay 1.5 as it's usually within the 40. That's correct, right?
I'm here.
You do not pay time and a half for comp time? Was that what your question was?
This was Rosalie. She's typing, it looks like. She says correct.
Okay, let me go down. Okay. No, you're supposed to pay comp time at time and a half under the Fair Labor Standards Act.
Do they have a contract? Do they have a labor contract?
Shouldn't matter. Even a labor contract shouldn't matter in this particular case. Okay. Okay. Shirley.
Hi, this is Shirley. I'm not sure I understand the question. If you are working within 40 hours in a week, why would you be paying comp time? If the person is working more than 40 hours, I thought that's when you would be paying comp time.
That would be correct. So, did I misunderstand the question?
It's down the bottom of chat right now. It says, yes, we have a labor contract, even if it's within 40 hours. And she's typing some more, it looks like.
We do comp time. That's usually with. Okay, if it's within the 40, then no, you don't need to pay time and a half. But usually, comp time is provided for hours over 40. And if the hours are over 40, then it needs to be at time and a half.
Oh, sorry, I turned off my mic.
Does that answer the question?
What you're talking about is more like a work week adjustment. It's still 40 hours within the week, and so it's only at time, which is my understanding is that's correct. It was not time and a half as long as they're under 40 hours for the work week. Is that correct?
That's correct. Yes,
Rosalie,
that is correct.
Is that what you were intending as well to answer your question? Yes.
So she's saying, okay, then I mean we get credit for extra hours. Oh, I see. I see what you're saying. Within the same week, yes. You can make those adjustments within your 40.
All right, I think she's good.
That was the part I didn't understand. Okay, good. Okay. Somehow my slides slipped way ahead. Okay, so now we're going to this. We're talking about the communication with your employees. So how do you treat your employees? Because their success or failure may depend on you making sure they have all the information they need. You really need to have an employee handbook. If you have everything in writing and in the hands of your employees and they have acknowledged receipt of the handbook, you will be covered if you receive complaints and excuses. For a newly hired employee, a handbook will explain what your company or organization does, what management expects from its employees, what the law requires of the employer, and in our state, we are an at-will state, which means employment is at will. And that means that the employee could quit for any reason, or the employer could terminate somebody for any reason. You do need to be a little bit careful about that, simply because the at-will has been undermined a bit. So you really need to have some basic reason, not just because you don't like the color of their hair. Okay? For all employees, a handbook will provide your work week definition, time off rules and expectations, designated pay periods and pay days, and any other legal or company guidelines or policies and procedures that you want to include in it. If you have employees, it's guaranteed that you will have complaints. Just be sure to listen to them and respond appropriately. If you have employees, there will be circumstances when misconduct will occur. Again, be sure to respond appropriately and document all such conversations. Remind them all of the handbook. If you have all of the subjects that are important in their employment in your handbook, then it's in writing and they should be able to find it. But be sure when you have those conversations to document them. It always pays off in the long run if you take the time to document. Documenting is the mantra of human resources. On this subject, I'm going to let Lynda talk about this subject.
We'll let Pam rest her voice for a minute. She really has a lovely voice. Today is not a good example of what she normally sounds like. We're going to take just a minute to look at why an employee might leave or why they might choose to stay with your organization. Hopefully it's the more positive. We all know that hiring and training are very expensive and they're very time consuming, and you just love somebody and you get them up to speed and they leave. And there's sort of a myth on the street that they left for more money or they left because somebody bullied them. But if you really look at the research, and there's actually, and you're all librarians, so you're like really good at research kinds of things, and that really is an area that I enjoy as well. If you take a look at some of the more credible research being done out of the universities, there are people divide it differently, of course, based on their journal articles, somewhere between 4 and 9 reasons that people end up leaving, and you end up losing the investment, and we really want that investment in our employees to pay off. So why do employees leave? The number one reason is understanding of the organization's accomplishments and their contributions. The most common reason an employee might leave your organization is they never understood the organization's goals and accomplishments and where they fit into the picture or how they contributed. It's difficult for a new employee to know how they play a part in the organization's goals if it's never explained to them. And you say, well, you're a library. Well, you all know that libraries do a whole lot more than the traditional definition of a library. And how does this new employee fit into the making the milieu what you want and providing the services that you are needing, having a strategic plan, having that be part of your employee handbook, and having a really good definition of the employee's work helps them understand where they fit into that strategic plan. And by the way, it's really important to make sure that all of your job descriptions do fit into that strategic plan, because sometimes we've found that isn't the case, and that can be a real missed opportunity to communicate. The second most common reason is poor supervision. And that's not to be confused with not liking the supervisor. We've all heard people say, oh, well, I didn't like the supervisor. By and large, these surveys found that the people on an individual level liked the supervisor, but the employees were citing the need to have their questions answered, have them answered in a timely way. They want feedback on their progress and how they're doing. They want training. And they also want evaluations. It was surprising that if you really look at some of the baseline research indicating that a lot of people said, I left after 3 years because nobody ever evaluated my work, and I want to grow as a professional, and I didn't understand how I could do that in that position because they never really talked to me about it. So it's just a really good time to sit down and talk with your employees when they're brand new and say, maybe my job is to help you really enjoy this job and to get you ready for the next job, whether it's with this organization or not, and to open up that line of communication. It's a really important part of what will make a person have a sense of wanting to stay with your organization. The third most common reason was a feeling of belonging and being part of a team. And of course, we all know that different assignments require various amounts of interactions with other employees. But most employees indicate that they want to be part of joint problem solving, even if they don't work in direct contact with other employees. They like to feel like they're making a meaningful contribution, again, to the goals and the strategic mission of the organization, and they like a sense of shared experience. And if you have people working in isolated situations, even though they may, by style, be kind of introverted, there is a sense that they want to feel like they're sharing in the experience of the whole organization and are valued, because that's part of the retention. And closely related to that, and as I said, these are sometimes organized differently, we tried to synthesize them a little bit for today's presentation, is morale. And that comes under, does the organization have a positive culture? How does it handle bullies? And let's face it, we're all going to get the occasional person that doesn't fit in or likes to play one-upmanship or whatever it is that makes it harder for an employee to come to work and feel good about their environment. How does it handle budget shortfalls? Most of us have been through that in the last 6 or 7 years if you've been around. I was actually in a situation where we had to lay off a quarter of our employees, and certainly part of managing that process was to show where the cash flow was or wasn't, or where it had been, or where the demands of services had been, and how did they handle other challenges. And we all have come up with different challenges, whether it's moving to a new building or technology changes, and how do you get your employees through that particular process, and is that successful? You want to keep up that communication with your employees, both talking to them and listening to them. It's a very important part of establishing a positive culture where your employees want to come to work. So with that, I guess I'll turn it back over to Pam, who is going to talk a little bit about the other end of the spectrum, which I guess is is this the A to the Z, the hiring to termination? Hopefully you don't get to the Z.
Okay. We are going to talk about hiring and terminations, and we'll start with the hiring process. Resumes are okay, but you always want to get a formal, organization-specific application from any prospective employee, especially if you plan to interview them. Sometimes you might just collect resumes if you have an open job, but when they come in to be interviewed, make sure that they have filled out your application. There are certain statements that should be made on all employment applications that really help the employer in the long run. And when they're signed and acknowledged that the employee has been informed, for example, at-will employment, disability provisions, permission to check references, disclaimers for promises to hire. You'd be amazed at how many cases there have been out there of people who filled out an employment application and thought they were promised to be hired because they did that. So you need to have all of the little legal things, the check boxes on your application so that people will read them and acknowledge the fact that they have done so. It is really important that you check references. In this day and age, sometimes that's really hard to do because of court cases where that employers have lost because they have passed on derogatory information about people that have worked for them. That's why it's important that you get written permission from a prospective employee that will allow that former employer and other references to be specific in the information that they are able to impart to you. Most former employers, as I said today, severely limit the information that they will give out. This person worked here from this date to this date, and they held this position in this position, and perhaps rates of pay, maybe. But if you have provided them with a specific signed permission from the prospective employer, they are much more likely to talk to you. Okay, you should have an onboarding process on the employee's first day of work. Onboarding is kind of a new term. that has taken off in the HR world, but it includes all of the legally required paperwork and providing new employees with the information that you want them to have about your organization. This is when you would give that new employee a handbook with an acknowledgement that they are to return within maybe 3 days, that they have reviewed the handbook and understand the provisions contained therein, and sign on the dotted line saying they have done so. You should also at this time give them a job description and make sure that they read it also and acknowledge the fact that they have read it and understand primarily what their job is. Sometimes it's hard when a person first comes to work to a new job to completely understand everything, but you should be able to include the majority of the major duties of a job in a job description that they will understand. Now, if your employees are not properly trained, and if they are not meeting your standards, if they are not counseled, they won't know that they're doing anything wrong. So you need to monitor, counsel, and train new employees to your standards. There's a great likelihood that they may fail if you don't do this. And then you'll be dealing with the next subject of discussion, which nobody wants to deal with. You cannot assume that a new employee will know what you expect by your company, even if similar experiences in their background. Every organization works a little bit differently within the confines of their own business. Okay, our next subject is the termination process. The biggest thing I can say is don't let situations that may lead to termination eventually slide. Handle them in a timely manner and have a process to handle it. It is wise to have a progressive process. You want to counsel, perhaps give verbal warnings, written warnings, and depending upon the infraction, perhaps a little time off without pay before actual termination. You also need to include this progressive discipline policy in writing in your employee handbook. In every conversation you have with your employees, document, document, document. Even if it is a verbal warning, document that verbal warning and have the employee sign acknowledging the fact that it occurred. It's really important to make sure that you have every step in the process written down, because employees often misunderstand, especially when it comes to termination, what you have already said to them. If you have it written down, you're okay. There are some situations that may require immediate termination, but in any such urgent action, it should be an egregious and rare situation. For example, life-threatening activities. And you can list in your employee handbook what types of behavior will not be tolerated. If you have a union shop, be sure that the employee is allowed a steward and is accorded a post-termination hearing for a last chance consideration. The National Labor Relations Act requires what is known as a Loudermill hearing. The Loudermill hearing came out of lawsuits because these last chance hearings were not provided. And again, always document everything. It only takes one wrongful termination lawsuit to cost you a lot of money, your organization a lot of money, and perhaps even you, your job. there are many laws that can bring this about. Unfortunately, we live in such a litigious society that it's necessary to take the time to document any and all disciplinary actions. As I said, document, document, document. Yes?
I was going to say there's a question that just came up. Should a library employee be allowed the option to appeal to the Board of Trustees upon termination?
Does a library work in any kind of an organized labor situation?
No, not typically.
Okay. I would say that that is something that would be up to your Board of Trustees, perhaps, a policy that they might have, that if they feel it's necessary to provide that last chance for an employee, maybe they could have a policy that would state yay or nay, or maybe it would need to be an egregious situation, which they might consider listening to.
As Michelle points out, usually a board is only responsible for the director and not the staff. Unfortunately, Carolyn Peterson, who usually runs First Tuesdays, could definitely speak to that. Shirley, can you speak to it by any chance?
It's correct that the Board of Trustees, usually they hire the director, and all of the other hiring and the personnel processes are part of the director's responsibility. It would be a very unusual situation for an employee to go over the director's head directly to the Board of Trustees. I would say that would be something that would have to be, again, part of a process that was both in the Board of Trustees policy and in the library's process, that there would be, but it would have to be I mean, frankly, if an employee had a complaint against the director, they'd probably be more likely to be suing the whole library and going through their own attorney rather than going to the Board of Trustees for the kinds of things I'm thinking of. So usually it's correct that the Board of Trustees hires the director, and the director is the person who hires and takes care of the rest of the personnel matters.
I think that's probably that's true in most public agencies. If there is a board of commissioners or a manager that has been put in charge by the elected officials who are in charge of whatever the organization is, that it would be very rare for an employee to actually go to that body to appeal a termination or any kind of disciplinary action.
And I guess I would like to add just a little bit here. It's really important for boards to have a set of policies or, if you will, standards and parameters. A lot of boards don't, but it is always good to have one that says, you know, this board's relationship is with the director, and that's the final operating authority for organizational purposes, and the board will only enter into discussions with regard to the employment of the director.
I might also add, this isn't about terminations, but if you are a small library and you don't have access to a human resources professional, it's a good idea from time to time perhaps to go out and have somebody come in and do an audit of where you are with your human resources policies, where you are with your handbooks, to make sure that there isn't something that has a new law that has come up that you're not aware of because you don't have direct access to a human resources person. That's just a good practice to get into for your own organization's safety, so to speak.
There are a couple more
Were you
comments.
going to say something, Jeremy?
One in regards to
Okay.
conversation. Jean Williams says there's no provision in the RCW that she's found, but it is in other state statutes that the library employee may appeal to the board. I'm unsure on that myself. We may need to look into it a little bit further, honestly. Shirley, I'm trying to remember, is it you or Carolyn that's doing the board governance and the like? It's you, isn't it?
Yes, it's me.
Okay. Can we type your email address into the chat for Jean? Perhaps you guys can put your heads together and see what she's found so far, and maybe we could figure something else out, or figure out an answer for that. Oh, okay. Never mind. I forgot.
Sure.
Yeah, we have so many out-of-state folks here today.
Yes, and you know, we're also speaking a lot for Washington because that's where we are. But I've had several years experience in California as well, so I can speak to some California law. But as far as the other states are concerned, I'm not specifically informed as to what the legalities of those kinds of things are.
Okay. Well,
for example, in Wisconsin or Georgia.
Let's not mire today's session down. I mean, we're actually closing on 10 o'clock right now. So I just put Shirley's email address in there, and perhaps we can figure it out. Bessie also says, is there liability insurance for the assistant director and the managers when an employee sues? I think there's insurance for the board and the library director. And then down below, should an attorney or HR professional review the library policies to be sure that they do not violate state or federal laws? So it sounds like two different questions there. Pam, you've turned off your microphone.
I'm sorry. I was clearing my throat and turned it off. I would say, as far as the liability insurance is concerned, that's probably a function of your board of directors to make sure that the people that are in charge are covered under their omissions and what's the other word? And insurance. I think that in this state, most of them are covered. And if a library is sued, it's generally the board that deals with the attorneys, and I'm sure the library director would be involved. So, and the second question was, it's not a bad idea to have an attorney review your policies to be sure that they don't violate state or federal law. There are also HR professionals out there who can help you with that. I don't mean to toot our own horn, but we stay up on all those things. And so it's something that we have a lot of experience with. And if we feel it's something that we can't answer, we will make sure that you get the word to do it. Talk to your attorney. Does that cover it? Hello?
She's typing. One moment.
Okay.
Yes, thanks.
Okay, good.
And before we continue on, it does look like we're probably going to run a few minutes late here, but we're just about done. Or we're on the last slide. Never mind. I'll let you.
Yes, we are. Okay. Well, this was our last slide. We were just going to say, if there are any further questions, please, now's the time to ask. Pardon my squeak.
Okay. Well, we do have an association with a labor law attorney in Olympia whose background is actually working primarily, he does some private sector work, but it's mostly public sector work, to look at the legal issues. I know that in Washington State, you will occasionally find where a Washington Administrative Code is in conflict with an RCW or expands an RCW in a way that the court might decide that the WAC exceeded the legislative intent of the original RCW. So it's fairly complicated, and my best guess is that there is so much difference between the various states that you really need to have somebody that knows your particular laws or can take some time and research them. And that's what you have either a labor law attorney or an HR professional to take a look at for you, so that if your handbook is being updated or if your strategic plan is updated, that they do that final check to make sure you're in compliance with all of your own local regulations. We also run into some things in Washington State because of the different configurations and funding strategies of various libraries that, for example, the final appeal authority might be different in one area than it would be in a city or a county than it would be in some other part of the state. So it's always good to make sure that everything is locally tailored to where you are and what you're going to be held accountable to.
Okay, any further questions or comments?
For those who haven't read the chat, Shirley, let me post the link there. Kathy Carter says, in the case of sexual harassment, employees have the right to go to the board in case the director is at fault or not taking the situation seriously. So it might make sense that in case of termination, an employee might, to ensure fairness, that he or she could make their case to the board. Just thinking.
That's entirely possible. And I would think that that might be something that should be in your board's policy manual.
And Shirley's just pointed out a great resource, the Municipal Research Service Center, and gave you the link to that. And they're a great place to go and look for information.
They are a good resource. They're also a good resource of sample policies.
Shirley, did you have another?
Hi.
Did you have another?
Yeah, I was just going to say that definitely the previous comment on, for example, if there's something like sexual harassment or a situation where the employee is not feeling safe and for whatever reason can't work through the director, that employee would probably approach the board of trustees. But that's the kind of horrendous thing I was thinking of. But I think that it's, again, that would probably be something that an employee would, I hope, would be getting legal counsel and very possibly would go through the board of trustees through their legal counsel. But I think that's absolutely correct. The board has to be ready for those kinds of situations that come up, and they're also going to be needing to get help from their legal counsel.
Well, it's also good to keep in mind that regardless of what the policies on the books are, you still may have an employee that comes during public comment at an open public session and brings something up, and you need to make sure that your board is prepared for that. Also, of course, the media involvement can cause us to not have a good experience and have us be in a position where we may not have policies that is broad enough to cover everything that might happen. And there again is the time that you probably want to be using your board's attorney, working with a consulting service, not necessarily us, but such as our own, because we do a lot of that media piece and that working through the process when it kind of went beyond or did an end run around the policies that were on the books.
Okay, I think we're over 10.
Well, thank you, Lynda and Pam. Great presentation, really great information, and appreciate your joining us today to share that.
It was our pleasure.
It's been a lot of fun. Make sure people know they can get a hold of us if they want to follow up on any of this.
All right, thank you everyone for joining us. If there's nothing else, next session will actually be November 3rd, High School 21, and this is it's a competency-based high school equivalency program for those that would like to join us. Same time, same link to get in, and we hope to see you there.